Back to the channel. I hope all of you are doing well. I'm Niladri Mukherjee. I'm a regulated Canadian immigration consultant and I practice in Windsor, Ontario, Canada. If your permanent residency application is being refused and if you're planning to go for a reconsideration, probably this video will be useful for you. So first and foremost, you need to understand that the reconsideration is not really your statutory right. IRCC may decide to even respond to your reconsideration or even may not even respond to your reconsideration at all. Though from my experience, I could tell you at least 60 to 70% of the times, yes, IRCC indeed respond to the reconsideration. It could be yes or it could be no, but at least they respond. So if you think that your case has a merit, then it probably does make sense to proceed with the reconsideration, specifically because judicial review is a whole complex process altogether, right? Now, but here are some things that you need to keep in mind. Each reconsideration request should be channelized and approached differently. From our experience, I could tell you this, at least from some of the recent success stories. In some cases, IRCC was at fault, but in other cases, my clients were at fault, right? So if I am responding to a reconsideration request and I'm placing a reconsideration request where I know that IRCC probably was at fault because they did not share a procedural fairness letter, then I will play in the ground that the IRCC officer breached the very principle of procedural fairness because he did not follow the proper administration of act and proper administration of facts, or it could be both. If IRCC sees some merit in my reconsideration request, they would ideally reopen the file and would then send a procedural fairness letter. Then all the other profile specific issues need to be dealt with while it responds to that procedural fairness letter, not as a part of the reconsideration request. This is a major mistake that I see. If IRCC is refused your application saying that you did not perform that job responsibilities for a very specific NOC, but IRCC did not send a procedural fairness letter to you before refusing your application, generally speaking, from my opinion and experience, your approach should be to tell them whether they have administered the acts and the facts properly and request them in a legal way to reopen the file. If they decide to reopen the file, then they will send you a formal procedural fairness letter, then explain about the NOC situation properly. But the NOC situation, etc., should not ideally be a part of your reconsideration request. Okay? That is when I mentioned when IRCC was at fault. But in some cases, I have also seen where my clients were at fault. For example, one of the clients applied under FSWP, but he thought that he was applying under the CEC and therefore did not provide a proof of fund. So I therefore, requested IRCC to reopen the file, give him an opportunity to provide the proof of fund, etc. IRCC thankfully listened to it. We will then send a formal PFL. We then responded to the PFL and the file has now been approved. There was another example where my client just did a very basic mistake and because of which some of the important documents have not yet been submitted. IRCC did not even receive those documents even though my clients uploaded those documents but not submitted. A very basic mistake, but in the end IRCC did not receive those documents. They refused that application. We played on the humanitarian compassionate grounds, cited all bunch of case laws and everything, told them that, well, it's an innocent mistake, because of which probably somebody's life should not be shattered like this. They were kind enough, reopened the file and then gave us an opportunity to provide those documents, those updated documents within a certain time frame. We have provided those. So each reconsideration request is approached differently for efficient result. Okay, but again, there are times when I request my clients that even not to proceed with the reconsideration because in my assessment those situations are not worth of spending time, money and energy for a reconsideration, right? So not every situation calls for a reconsideration, but those very few specific situations that it does make sense in my opinion to consult somebody whom you can trust, understand how it works and then make a proper reconsideration application. There is no point in like submitting a reconsideration just for the sake of submitting because whatever you are submitting is getting added to your GCMS. So if you need our assistance with this kind of complex reconsideration, more than welcome to hop into our website nuvonation.ca, book our relevant professional consultation. Happy to discuss.